watching News Epicenter with me, Marya, Shakil. A massive political face-off has erupted between the BJP and the opposition over former Supreme Court Judge Syed Abdul Nazeer's appointment as the Governor of Andhra Pradesh. Just 5 weeks after his retirement, while Andhra Pradesh Chief Minister Jagan Reddy welcomed the move, saying it is a privilege to work with Justice Nazeer, the opposition is crying foul over the appointment, calling it a threat to judicial independence, citing the fact that Justice Nazeer was part of the bench that delivered the unanimous Ayodhya verdict in favor of the Hindu side. The opposition claims he has been rewarded for the Supreme Court verdict that paved way for the Ram temple that is set to open its doors early next year. Union Law Minister Kiren Rijiju hit back at the opposition, saying that the left ecosystem cannot treat India as their personal fiefdom, citing that no provision of the Constitution has been violated by Justice Nazeer's appointment. This fresh showdown between the centre and the opposition seems to be ignoring past precedents and the rules laid down for the appointment for former judges, even the norms set for the cooling off period. The point of attack is the fact that Justice Nazeer was part of the Ram Mandir bench, with the fight also coming amidst the tussle between the centre and the judiciary over the collegium system. But can the opposition, namely the Congress, make such charges in isolation of past precedents and rules? That's our top focus on News Epicenter.
Who have served in the apex judiciary, should they be accepting such post-retirement sinecures?
जिन्होंने आपके बारे में फेवर किया, उनको कुछ ना कुछ फेवर आप कर रहे हो.
Congress party itself had laid down the convention of giving positions to the retired judges. Some allegations on such appointment, I think it is not proper on the part of any political party.
अगर कोर्ट में फैसला पक्ष में नहीं आया तो सुप्रीम कोर्ट को गाली देगा, उसकी आलोचना कर देगा.
To decode the matter, let's first give you an overview of the landmark rulings that Justice Nazeer has been a part of. Right before his retirement, he was part of the bench that cleared the centre's demonetization decision. He was also on the bench which ruled that there will be no additional curbs on the free speech of legislators. The court was hearing pleas citing an alarming rise in hate speeches by elected representatives. These were in 2023. But in 2019, he was part of the 5-judge bench that finally ended decades of long dispute, paving the way for the Ram temple in Ayodhya. And in 2018, just a year before that, Justice Nazeer was part of the Supreme Court bench that held privacy to be a fundamental right, while in 2017, he was part of the minority opinion in the 3-2 ruling which opposed the ban on triple talaq. So it's not fair to allege that he championed a political agenda when he was part of the Supreme Court. In fact, when we look at past appointments, Justice Nazeer is not the only Supreme Court judge to be elevated to the post of the governor. In 2014, Justice Sathasivam was appointed the Governor of Kerala 4 months after his retirement in April. In 1997, Justice Fatima Bibi was appointed the Governor of Tamil Nadu 5 years after her retirement in 1992. If we go back further, Justice Syed Fazl Ali, who retired as a judge in May 1952, was appointed the governor of Orissa the same year and then went on to serve as the governor of Assam. So you can see that this notion of a cooling off period is never really set. For now, there is no law. There is no law absolutely that restricts a retired judge from holding the post of governor. And in 2021, the Supreme Court refused to fix a cooling off period for judges. The top court, in fact, made the same observation in 2014, saying it can't fix a cooling off period for judges to take government jobs. However, a one-year cooling off period is set for retired bureaucrats. So we have seen this trend in appointment of top judges under the UPA as well. And this is what the BJP and the government is saying. Justice KG Balakrishnan, he retired in May 2010 and was appointed as the chairperson of National Human Rights Commission in June 2010. Just in a month's time. Justice A.K. Ganguly retired in February 2012 and was appointed as the head of the West Bengal Human Rights Panel in March 2012. Justice M. Sharma retired in September 2011 and was cleared as the chief of the Vansadhara Water Dispute Tribunal 4 months before retirement. Then there was Justice L.S. Panta, who retired in April 2009 and was appointed as the chairperson of the NGT in 2010. So is the opposition really in a position to judge the appointment of Justice Nazeer? I'm going to take this question to the panelists who are joining me live. Aryama Sundaram, Senior Advocate of Supreme Court. Vikas Singh is President of Supreme Court Bar Association. P.K. Malhotra, former Law Secretary. Jaiveer Shergill is BJP spokesperson. And Aadil Hasan is MIM spokesperson. I'm going to begin with the lawyers first. Aryama Sundaram, there is no legal bar in the Constitution which stops the government from making such an appointment. However, this is a question of propriety. But isn't this almost an outdated idea to talk about cooling off period, because it's something that's not followed and it remains mostly in the domain of political slugfest?
Well, to answer you directly, I don't see where the propriety comes in this issue. You are right that there is no such thing as a cooling off period, and I fail to see what the whole controversy is about. According to me, it's much ado about nothing. And let me tell you why I'm saying this. Look, there are three kinds of appointments which can follow after retirement of a judge. There could be appointments which are purely political in nature. There could be appointments which are constitutional in nature. And there could be appointments which have to do with heading tribunals. All this nonsense which has been spoken about, judges who have retired from the Supreme Court being appointed to tribunals, obviously the people who are saying it have not read the legislation or are not aware of the legislation. Because the tribunals or acts which are setting up the tribunals mandatorily provides that the chairman of the tribunal shall be a retired judge of the Supreme Court or a retired Chief Justice. So it is only retired judges of Supreme Court or retired Chief Justices who you appoint to the tribunal. And usually you appoint judges who are retiring at about the same time a vacancy arises. So there's no gap in any great vacancy in the tribunal, because that's the only way the tribunals can function. So for people who are objecting, the chairman of the National Human Rights Commission had to be a retired Chief Justice. The chairman of the National Green Tribunal had to be a retired judge of the Supreme Court. Or the chairman of the NCLAT, that is the National Company Law Tribunal, has to be a retired judge of the Supreme Court of the High Court, Chief Justice of the High Court. So these objections are meaningless and come from people who obviously are not aware of the legislation or who have not read the acts. Now let's come to the second, purely political.
Yes.
Here, there could be some room for criticism of other political parties, saying here was a judge of the Supreme Court, today he has joined this political party, become a member of the one of the houses of parliament on the flag of this particular party, and has really become a party man. There could be room for criticism. But so far as constitutional appointments, we've had Justice Subbarao, who stood for election as the president. We had Chief Justice Hidayatullah, who became the vice president.
Yes.
We had Justice Hegde, who thereafter became a Speaker of the House. Now listen, these are eminent people. Now let's understand constitutionally The governor is meant to be a very eminent person. The governor is not a pure political appointment. In fact, the screaming of everybody is, oh, the governor's office is being politicized. The governor constitutionally has to be like a father familias, like a patre familias of the state. And the governor is being politicized. Yet when you put a non-political person there, when you put a person, an eminent person who has been a very distinguished jurist there, who would aptly fill the office, where is the question of objecting? Then what are you saying? It should only be a political person. On the one hand, you're claiming that the post is becoming political. On the other hand, you're complaining when a non-political person is being put there and saying, look here, that means this person is really under the surface politically inclined to a party. On the contrary, I remember in the old days, Jayachamaraja Vadayar, the old erstwhile Maharaja of Mysore, very erudite man, was made the governor of Madras.
Yes.
We've had great governors who have occupied the offices because of their eminence. The politicizing of the office is being done by the very political parties who are today screaming about it.
Yes.
And so far as Justice Nazeer is concerned, on the bench, he had all the respect. He had the greatest regard for him. He was always considered a very fine judge. He's a man of great courtesy, great etiquette, great learning. He turned out to be a good judge. And I am saying that the state of Andhra Pradesh is blessed to have an
Aryama
eminent
Sundaram,
person like this
sir,
as a
you
governor.
have set up the debate very well, so thank you so much for your time and also for setting it up with a lot of historical data and of course the constitutional position on this. PK Malhotra, one view certainly is that it's one thing to be appointed to for the role of tribunals, because the tribunals require a former judge to head it. But what about a Rajya Sabha berth or even the role of a governor?
Well, first I would like to comment on the observations made in your opening remarks with regard to appointment of Justice Nazeer because of the certain judgments which you have referred to. I think that will not be the correct proposition, as Mr. Subramaniam has also pointed out. Justice Nazeer was a wonderful judge and the judgments were not given by him individually. They are the judgments given by a constitutional bench, having not 5 judges or 7 judges or 9 judges in the bench. So he is only one of the judge who has delivered this judgment. So it's a favor shown to him will not be a correct proposition, more particularly knowing the reputation which he enjoys in the judiciary and among the legal fraternity. Now, I think Mr. Subramaniam has also rightly classified that there can be 3 types of appointments of the persons retiring from the judiciary. One are the constitutional appointments. Second is the appointments made in the tribunal under the law made by the parliament. And third is made by the government in exercise of the executive authority. I think so far as the constitutional appointments are concerned, there is no question mark on that. So far as under the Acts of Parliament, if the law itself prescribes that only a retired judge of the Supreme Court or High Court will be appointed to the tribunal or the commission, I think no question should be put on this kind of appointment, because they are all statutory appointment governed by the law made by the parliament. It is only the third category where you are appointing somebody as a member in the Rajya Sabha or say appointing as a governor, where this kind of questions are being raised. Now let us not forget that appointment of a governor is also a political appointment on the because this is made by the president, and the only qualification prescribed for appointment of governor is that he should be a citizen of India and he should be of 35 years of age. That's the only qualification prescribed, and it goes without saying that this kind of appointment which are made by the political parties or the party in power is the executive power which is exercised through the President of India. So in this case, there is a scope of making political appointments. So if the person from the judiciary is appointed immediately after his appointment, there can be people who will raise question to this kind of appointment, and that is what is being done. But it should not be taken for an individual that is casting any aspersion on the individual. Okay. It is a systemic thing which we are talking, that whether this kind of appointment immediately after demitting the office should be made or not. Even Mr. Arun Jaitley is on record having said in the parliament that if the judges are appointed to this kind of political posts immediately on their retirement, probably a doubt is raised on the independence and impartiality of the judiciary, and also that in future the people who are going to deliver the judgment, they are guided by this kind of, they are rather persuaded to see that they give a judgment in favor of the government.
Okay.
I think if this kind of statement has come from a person none other than Arun Jaitley,
yes,
that has to be taken seriously. And the period of cooling off which you were talking about in this third category of appointment appears to be a point for consideration.
Okay. Aryama Sundaram, before I bring in Vikas Singh and then I will get in the politicians. Aryama Sundaram, while you argue well that, as far as the governor's role is concerned, it is supposed to be a political, and the political slugfest that we are seeing in multiple states is also an example of how he is looked as a political appointee, and that is also the truth, sir. My question then is that if there is a cooling off period for retired bureaucrats, there is a cooling off period in other categories, shouldn't it be there also in the case of judges? Just a cooling off period. Thereafter, maybe after 6 months or a year, the person, because he is of course a retired Supreme Court judge, a person of great eminence, he can be moved to any position.
Look, once it is accepted that a judge of a Supreme Court could thereafter take office as a governor, and let us also accept one thing, as a judge of the Supreme Court, when he accepts office as a governor, he does not step down in protocol, he in fact steps up in protocol. So there's no problem there. Once you accept that he can take office, where is the question of a cooling off period? And don't compare a retired bureaucrat with a retired judge of the Supreme Court. The retired judge of the Supreme Court is a constitutional office. He is appointed under the Constitution. He is a constitutional authority. Whereas a bureaucrat is appointed by various service laws, by a different format of appointment altogether. He's a government servant. He cannot be compared with a judge of the Supreme Court. Secondly, when a judge of a Supreme Court is appointed to such an office, you are basically dignifying the office. You are in no way giving this judge a favor. Let me assure you that eminent judges of the Supreme Court, after they retire, they can take up arbitrations, they can do various things, they can make enormous amount of monetary, enormous amount of earnings after that. But when they take up offices like this, I think you want them to share their experience in an important office, and especially the office of a governor, an official who should be well aware of the Constitution, and an office where the governor is meant to be aware of constitutional rights, constitutional duties, and is meant to be a person who is well charged, well in knowledge of the Constitution. Who better than a retired judge of the Supreme Court? I think it's very good. I don't see anything wrong in it. And in this case, certainly in Justice Nazeer's case, I think there's been much ado about nothing. It's become a case of objecting for the sake of objecting, because not a finger can ever be pointed at any kind of political favors being given here in this case.
Okay. Vikas Singh, which side of the debate are you on? Because the jury certainly is out on this. There are views that there should be a cooling off period, and also there are views of Aryama Sundaram who's saying that this is much ado about nothing, because if anything, a retired judge brings that experience, knowledge of Constitution when he takes the role in a Constitution office such as the Raj Bhavan.
So, Marya, there are several appointments where retired judges get appointed to. Now, some of these are, like the tribunals or the NHRC, where the act or the statute itself provides for a retired Supreme Court judge to be appointed. Now, in those cases, for having a judge or the Supreme Court to be taken in immediately after retirement, it can't be questioned, because ultimately you have to get somebody who is the Supreme Court judge, unless you set aside the statute itself or question the validity of the statute itself. But a governor's position or a Rajya Sabha position, which is a position which is a purely political appointment, I would say, and when saying that, I have nothing against Justice Nazeer. I think he's a very fine human being, and no fault can be found with his particular appointment. But I feel that there should be a 1 year cooling off, because, or maybe even more, a 2 year cooling off, because then because when you say justice is to be done, the principle is that justice should not only be done but seem to be done.
Yes, that's right.
if a judge is, wanting this kind of an assignment, pre-retirement, and if he actually gets it, it's a dangerous trend. And this trend should not be according to be encouraged at all. And if a person does a 1 year cooling off period, then things will change. Maybe politics may change. And his worth of being considered for that appointment will purely be on merit.
Okay, let me bring Adil Hasan. Why shouldn't his appointment then, Adil Hasan, be seen from the point of view of merit? Is this much ado about nothing, as Aryama Sundaram put it rightly?
Ma'am, my point is that why BJP Katni and Katni is always different. Why BJP change its stand with its comfortability. What Mr. late Arun Jaitley told in the parliament in the legal cell seminar before the BJP advocates. Why the thing was backed by Mr. Gadkari. Why even Justice Thakur told that there should be cooling period of 3 years. Justice Chamreshwar left the residence very same day when he retired from Supreme Court, but Justice Arun Mishra got the extension every month. He got the extension in the Lutean zones. It's the question. BJP change stand. BJP thinks that they can change stand according to their comfort level. My question is that we are not questioning the integrity
but then why are you objecting to the appointment of Justice Nazeer in particular?
No. Why we don't have? It's the India is a democratic country. We have all respect for Supreme Court judges, High Court judges. But the same thing in Kerala. In Kerala, Chief Justice Antino retired. He got the State Human Rights Commission. The same we have A.K. Goel Sahib.
So basically, Adil Hasan, there is just about every government or every party has done something like this. So there are precedents, so nobody can take a position politically. Yes, both of them have done it. Jaiveer, Shergill.
Congress is equally responsible.
The point being made here is that it's not about right or wrong. It's about what the BJP said when they were not in power. And it was said by late Arun Jaitley himself.
Yes, my question is that. And Law Minister, he was Law Minister, Honorable Law Minister.
Go ahead.
Marya, if the gentleman has finished and has extended me the courtesy to finish, I have 3-4 arrows in my quiver on this. Number one, the appointment of Justice Nazeer is per constitution, per past precedents, and per his talent. He has become governor not as somebody's Nazare Inayat, but purely because of his capability. Point number two, before I put on my political hat, the gentleman who is speaking, his party head, Mr. Owaisi, vows by the constitution. I have the constitution book in my hand. Article 124(7) puts only one restriction on Supreme Court judge, that he or she cannot practice in any court of law. So drafters of the constitution, if they thought in their wisdom to put any restriction, they would have, on the appointment of judges as governors, they would have done so. Number three, opposition's objection to Justice Nazeer's appointment as governor reeks of hypocrisy, hollow criticism, and anti-mindset. Is the argument being made, if Justice Nazeer would have given a verdict directing Babri Masjid at the site, then he was qualified to become a governor? Just because he took the stand saying Ram Mandir should be constructed, he should not become a governor. Are we saying is that rather BJP has shown the government of the day that the political climate is such that politicization of the judiciary and misuse of the judiciary has stopped? Appointment of Justice Nazeer as a governor sent the message that the era of politicization of judiciary has stopped.
Okay, yes, the question is, we should not be looking at it because Ram Mandir verdict is not the only verdict that has been delivered by him. Let's not forget that he was part of the dissenting note also, the dissenting judgment, the minority judgment, in fact, in the Triple Talaq case. So to look at his entire the judgments that he has done from that prism may not be fair for a justice of great eminence such as Justice Nazeer. One moment, I'm coming to you. Aadil Hasan ji, रुकिए ना. Aadil Hasan ji, एक तरफ opposition ये कहती है कि one moment. Aadil Hasan ji, आप एक तरफ opposition ये कहती है कि जो राजभवन है वहां पर it should be a non-political person. So here is a judge. Someone who is completely well versed in Constitution of India. You should be celebrating an appointment of this nature. Rather than just looking at what he said from the Ram Janam Bhoomi verdict. It was a unanimous verdict. And if anything, showed that the entire judiciary viewed this entire issue, which was vexing the country for decades, from one clear prism. It had to go in one way.
Ma'am, to be very honest, nobody is questioning the integrity of Justice Nazeer. But for Mr. Shergill, I want to make him remember that in the history, independent history, first time Supreme Court judges came and attended the press conference. This was the blot on the government. You hope you remember that thing. 4 Supreme Court senior most judges came before the media. It was the history in Indian democracy, Indian judiciary. Nobody came like that. We are not questioning the integrity of Mr. Nazeer. But what Mr. Arun Jaitley told, what Justice Thakur told, Justice Joseph told, Justice Chamaleshwar told, what Nitin Gadkari was president that time, he backed the resolution that there should be cooling period. Even Supreme Court judges retired, they told that there should be cooling period. Our point is single.
Cooling off period endlessly.
Yes. I am talking about the cooling period. We should have cooling period. We have faith in judiciary.
Vikas Singh. While we look at various...
And I'm not going to get a chance.
You have people who are arguing for it, so I don't think so. You can make it about a monologue, please, Jaiveer, Shergill.
You have to
Jaiveer, Shergill, you have made your point. I'm going to bring in others. Vikas Singh, the point here is also of, it is being seen from the prism the way it is. Is this only because had it been about a tribunal, there would not have been much issue? Because in tribunal, it is clearly mentioned that the head of these tribunals must be a retired judge. Do you think it's, drawing so much of attention and criticism only because it is a Raj Bhavan and Raj Bhavans are seen as political appointments? We have seen in the case of Justice Ranjan Gogoi also, he was sent to the Rajya Sabha, although he was part of those 12, appointments or the 12 MPs who are appointed by the president.
Well, that also is a very big debate, according to me, even for tribunals. I would say this, that post-retirement judges should not be given any assignment. And even for tribunals, there is a need to amend these statutes to ensure that, why don't you have specialized people manning the tribunal rather than asking for only judges. So, for instance, a judge may not have done, any work in that particular branch of law. And a tribunal is invariably a very specialized area, for instance, telecom or electricity. These are very, very specialized, highly technical areas of, where tribunals function. And I would say that even for there, you should have people who are experts in the field to be brought in as chairman or members rather than, picking up retired judges. But that's a larger debate. And that debate, according to should happen, that judges should be completely ousted from any post-retirement appointment. And they should only either get their pension or permitted to do arbitration.
PK Malhotra, I want to understand from you, sir. Our constitution also says nothing against post-retirement appointment of judges. That's also a clarity here. Then all these talks, do you think, become just about forgetting what has happened in the past? There are countless times in the past where former judges have been appointed to different positions. You have the example of Justice Fazl Ali. You have several such examples which I spoke about just a few minutes back. The question then is, should the landmark verdicts of Justice Nazeer be seen from the prism the way it is being debated?
See, let us first look at this issue at a larger perspective. There are 3 organs of the government: the executive, legislature and the judiciary.
Yes.
And judiciary is supposed to be functioning independently of the other 2 organs of the government. The moment executive starts making appointment of the judges who have just retired on the posts, then the issue which I raised earlier, and as I quoted Mr. Arun Jaitley also having said in the parliament, the judges start looking for post-retirement appointment, and that affects their judgments. I think that is the issue on which we have to ponder upon. if you are looking for appointments in the commission in the tribunals, because they are deciding the judicial functions, so there is no question mark on that. It is only when the executive, in exercise of its executive power, making political appointment, this kind of issue arises, and therefore the question of cooling off period arises in this particular case also. If independence of judiciary is to be maintained, and you want to send a right signal to the common man that he will get justice from the judges, and they will not be influenced because they are going to get post-retirement benefit because they are giving a decision in favor of the government, I think then probably you are compromising with the independence of judiciary. With that kind of signal, if it goes to the public, will be very, very dangerous signal. So what we need is, as I said earlier, in case there is a cooling off period, at least in making these political appointments, which are purely guided by political consideration, of course they are meritable, no doubt about it, that a Supreme Court judge will prove to be a very good governor because he knows the constitution very well. So it's no question mark on the individual appointments.
Okay.
But what I am talking of the system as such, and if we have to follow the system, then you have to see that the independence of judiciary is maintained and the confidence of the common man on the ground is not shaken because of this kind of appointments.
All right. Thank you so much for your time, Vikas Singh, Jaiveer, Shergill, Aadil, Hasan, Aryama Sundaram and